Look, I know the internet is really, really upset about the order regarding the birthing video. And I understand why, because we're talking about something that implicates another woman who's not a party to this case, who is being dragged into it in ways that she didn't want to be, and now is having to have one of the most intimate and special moments of her life potentially be tarnished because of a party that is relentlessly seeking something that it arguably doesn't actually need. So I get it. And that at the same time, the courts are sort of soulless in that way, in that they look at just the kind of procedure, just kind of if this, then that. And that being said, there is some consideration for privacy interests and whatnot. But the law can be pretty harsh in that way. And in this case, the court said your lawyers didn't object in this particular way, which means that, you need to turn over this pursuant to the definition that makes sense to the court. It's very cut and dry. It's very emotionless. That's how a lot of these decisions are made. But at the same time, I can appreciate the public's frustration with it. So this question is one that I'm seeing a lot in my comments from my last video about what could Miss Heath do here. And she could have, filed a motion to quash potentially. She could have maybe written a letter. That may not have changed the outcome here, however. And at this point, it's about the parties negotiating something. So the court has ordered the video to be turned over. And actually, it's not entirely clear what video or videos they have to turn over, because there's a dispute as to what video was shown, and are we talking about all the births of all the children and all the potential videos, or is it the video of that still? It's actually not entirely clear from the order what is being ordered to be produced. So there's that. So if the Wayfarer parties, Heath, turns over the video, they could potentially say, look, this is very sensitive. We understand that you need to see this other thing to determine whether or not this is what you were shown, and you're entitled to it as pursuant to the judge. But this doesn't need to be saved in your computer files. Why not let's set up a meeting at Kevin Fritz's office in New York for Lively to show up with one attorney and Heath to turn up with one attorney, and for everybody to sit in the room, okay, maybe not the parties, but like maybe just the Lively, her lawyer, and the other side's lawyer, and they sit in a room and they watch it. And that's it. They don't need a copy of it. That could be something that they request at this point to stipulate to, like, okay, we'll show these to you or this to you, whatever it is, but we don't want copies of it stored on your hard drive at Wilkie Farr or Manat Phelps. We don't want every paralegal and every secretary and every partner and every associate at all of your giant firms to have access to this for the unfortunate accident that it could fall into the wrong hands. And I think that's actually a pretty reasonable request at this point. Because if the issue is that Lively needs to see if there was another video that she saw, then they can just arrange for her to see it and then determine, make notes of the timestamp or whatever. If she's like, that's the spot. That's the one that I saw. And then, they can do with it what they will. Because I think the judge says, like, this is not likely to be something that is going to be shown to a jury. This is not likely to be something that's going to be unsealed. That's what the subtext not even the subtext, that's basically what he says in the order. So I think there is still room to protect Mrs. Heath in this scenario. And, there's also a possibility that Heath could move to reconsider and, explain that it was, their understanding. And regrettably, the lawyers didn't object in the way that they needed to object. I don't know that that will work here. I don't know that the court will want to entertain that kind of motion, but that's available to them. So I do think the best course of action for the parties at this point is to agree to some professionalism and some protection for a woman that's not involved in this case. And if Heath and his lawyers, the Wayfarer party's lawyers, make this request of Lively and her lawyers, and they decline, well, that really says a lot. And I would be extremely disappointed that the person that is standing up, advocating on behalf of women, is not taking a reasonable step to protect the privacy and dignity of another woman. So, if the Wayfarer parties are listening, that's what I would request. And hopefully that can preserve the goodwill, integrity, and privacy of Mrs. Heath. I also want to address the fact that people are saying, well, he should have never brought it into the workplace to begin with. Maybe they were okay with the thing that he showed. Maybe the thing that he's claiming he showed, a still or a picture of after birth, was something that they were comfortable showing. But maybe they're not comfortable with sharing the video because they don't want to show the video. It's clear that he doesn't want to disclose that video, so maybe that was not part of the agreement. And this case is forcing their hand on this. This case is forcing them to bring that in. That's not something they could have anticipated. I mean, think about all the text messages that you send, the pictures that you send to people, your friends, your family, even your colleagues with respect to showing them things. Do you actually expect that they would become international news? No. So all that being said, I don't think that's a very strong argument. I think that's missing the point. The point is that as it is today, we have a woman's right to privacy, a child's right to privacy at issue here. And the Lively team can get what they want without further insulting and harassing them.